Dred Scott v. Sandford, 60 U.S. 393, was a landmark decision by the U.S. Supreme Court in which the court held that African Americans, whether enslaved or free, could not be American citizens and therefore had no standing to sue in federal court, and that the federal government had no power to regulate slavery in the federal territories acquired after the creation of the United States. Dred Scott, an enslaved African-American man who had been taken by his owners to free states and territories, attempted to sue for his freedom. In a 7-2 decision written by Chief Justice Roger B. Taney, the court denied Scott's request. For only the second time to that point in its history, the Supreme Court ruled an act of Congress to be unconstitutional. Although Taney hoped that his ruling would finally settle the slavery question, the decision immediately spurred vehement dissent from anti-slavery elements in the North, especially Republicans. Many contemporary lawyers, and most modern legal scholars, consider the ruling regarding slavery in the territories to be dictum, not binding precedent. The decision proved to be an indirect catalyst for the American Civil War. It was functionally superseded by the Civil Rights Act of 1866 and by the 14th Amendment to the United States Constitution, which gave African Americans full citizenship. The Supreme Court's decision in Dred Scott v. Sandford is unanimously denounced by scholars. Bernard Schwartz says it stands first in any list of the worst Supreme Court decisions. Chief Justice C. Hughes called it the court's greatest self-inflicted wound. Junius P. Rodriguez says it is universally condemned as the U.S. Supreme Court's worst decision. Koenig al. say it was unquestionably our court's worst decision ever. Background: Dred Scott was born a slave in Virginia in 1795. Little is known of his early years. His owner, Peter Blow, moved to Alabama in 1818, taking his 6 slaves along to work a farm near Huntsville. In 1830, Blow gave up farming and settled in St. Louis, Missouri, where he sold Scott to U.S. Army surgeon Dr. John Emerson. After purchasing Scott, Emerson took him to Fort Armstrong, which was located in Illinois, a free state. Illinois had been free as a territory under the Northwest Ordinance of 1787, and had prohibited slavery in its constitution in 1819 when it was admitted as a state. In 1836, Emerson moved with Scott from Illinois to Fort Snelling, which was located in the Wisconsin Territory in what would become the state of Minnesota. Slavery in the Wisconsin Territory was prohibited by the United States Congress under the Missouri Compromise. During his stay at Fort Snelling, Scott married Harriet Robinson in a civil ceremony by Harriet's owner, Major Lawrence Taliaferro, a justice of the peace who was also an Indian agent. The ceremony would have been unnecessary if Dred Scott were a slave, as slave marriages had no recognition in the law. In 1837, the Army ordered Emerson to Jefferson Barracks military post, south of St. Louis, Missouri. Emerson left Scott and his wife at Fort Snelling, where he leased their services out for profit. By hiring Scott out in a free state, Emerson was effectively bringing the institution of slavery into a free state, which was a direct violation of the Missouri Compromise, the Northwest Ordinance, and the Wisconsin Enabling Act. Before the end of the year, the Army reassigned Emerson to Fort Jesup in Louisiana. There Emerson married Eliza Irene Sandford in February 1838. Emerson sent for Scott and Harriet, who proceeded to Louisiana to serve their master and his wife. While en route to Louisiana, Scott's daughter Eliza was born on a steamboat underway along the Mississippi River between Illinois and what would become Iowa. Because Eliza was born in free territory, she was technically born as a free person under both federal and state laws. Upon entering Louisiana, the Scotts could have sued for their freedom, but did not. Finkelman suggests that in all likelihood, the Scotts would have been granted their freedom by a Louisiana court, as it had respected laws of free states that slaveholders forfeited their right to slaves if they brought them in for extended periods. This had been Louisiana state precedent for more than 20 years. Toward the end of 1838, the Army reassigned Emerson to Fort Snelling. By 1840, Emerson's wife Irene returned to St. Louis with their slaves. While Drive, Emerson served in the Seminole War. While in St. Louis, she hired him out. In 1842, Emerson left the Army. After he died in the Iowa Territory in 1843, his widow Irene inherited his estate, including the Scots. For 3 years after John Emerson's death, she continued to lease out the Scots as hired slaves. In 1846, Scott attempted to purchase his and his family's freedom, but Irene Emerson refused, prompting Scott to resort to legal recourse. Procedural history. First attempt having been unsuccessful in his attempt to purchase freedom for his family and himself, and with the help of abolitionist legal advisors, Scott sued Emerson for his freedom in a Missouri court in 1846. Scott received financial assistance for his case from the family of his previous owner, Peter Blow. Blow's daughter Charlotte was married to Joseph Charles, an officer at the Bank of Missouri. Charles signed the legal documents as security for Dred Scott and secured the services of the bank's attorney, Samuel Mansfield Bay, for the trial. Scott based his legal argument on precedents such as Somerset v. Stewart, Winnie v. Whitesides, and Rachel v. Walker, claiming his presence and residence in free territories required his emancipation. Scott's lawyers argued the same for Scott's wife, and further claimed that Eliza Scott's birth on a steamboat between a free state and a free territory had made her free upon birth. It was expected that the Scots would win the freedom with relative ease since Missouri courts had previously heard over 10 other cases in which they had freed slaves who had been taken into free territory. Furthermore, the case had been assigned to Judge Alexander Hamilton, who was known to be sympathetic to slave freedom suits. However, in June 1847, Scott lost his case due to a technicality. Scott had not proven that he was actually enslaved by Irene Emerson. At the trial, grocer Samuel Russell had testified that he was leasing Scott from Irene Emerson. But on cross-examination he admitted that the leasing arrangements had actually been made by his wife Adeline. Thus, Russell's testimony was ruled hearsay and the jury returned a verdict for Emerson. Scott v. Emerson. In December 1847, Judge Hamilton granted Scott a new trial. Emerson appealed this decision to the Supreme Court of Missouri, which affirmed the trial court's order in 1848. Due to a major fire, a cholera epidemic, and 2 continuances, the new trial did not begin until January 1850. While the case awaited trial, Scott and his family were placed in the custody of the St. Louis County Sheriff, who continued to lease out the services of Scott and his family. The proceeds were placed in escrow, to be paid to Scott's owner or himself upon resolution of the case. In the 1850 trial, Scott was represented by Alexander P. Field and David N. Hall, both of whom had previously shared offices with Charles Edmund Labome, the brother of Peter Blow's daughter-in-law. The hearsay problem was surmounted by a deposition from Adeline Russell, stating that she had leased the Scotts from Emerson. The jury found in favor of Scott and his family. Unwilling to accept the loss of 4 slaves and a substantial escrow account, Emerson appealed to the Supreme Court of Missouri. Although by that point she had moved to Massachusetts and transferred ownership of Scott to her brother, John F. A. Sandford. In November 1852, the Missouri Supreme Court reversed the trial court's decision, effectively overturning 28 years of Missouri state precedent. It held that the Scots were still legally slaves and that they should have sued for freedom while living in a free state. Chief Justice William Scott declared, "Times are not now as they were when the former decisions on this subject were made. Since then not only individuals but states have been possessed with a dark and fell spirit in relation to slavery, whose gratification is sought in the pursuit of measures, whose inevitable consequences must be the overthrow and destruction of our government. Under such circumstances it does not behoove the state of Missouri to show the least countenance to any measure which might gratify this spirit." Scott v. Sandford. At this point, the case looked hopeless and the Blow family decided that they could no longer pay for Scott's legal costs. Scott also lost both of his lawyers, as Alexander Field had moved to Louisiana and David Hall had died. The case was now undertaken pro bono by Roswell Field, whose office employed Dred Scott as a janitor. Field also discussed the case with Labome, who had taken over the lease on the Scotts in 1851. Following the Missouri Supreme Court decision, Judge Hamilton turned down a request by Emerson's lawyers to release the rent payments from escrow and to deliver the slaves into their owners' custody. In 1853, Dred Scott again sued his current owner, John Sandford, but now in federal court. Sandford had returned to New York, so the federal courts now had diversity jurisdiction under Article 3, Section 2 of the U.S. Constitution. In addition to the existing complaints, Scott also alleged that Sandford had assaulted his family and held them captive for 6 hours on January 1, 1853. At trial in 1854, Judge Robert William Wells directed the jury to rely on Missouri law to settle the question of Scott's freedom. Since the Missouri Supreme Court had held that Scott remained a slave, the jury found in favor of Sandford. Scott then appealed to the U.S. Supreme Court, where the case was misspelled as Dred Scott v. Sandford and entered history with that misspelling. Scott was represented before the Supreme Court by Montgomery Blair and George Ticknor Curtis, whose brother Benjamin was a Supreme Court justice. Sandford was represented by Reverdy Johnson and Henry S. Geyer. Influence of President Buchanan. Historians discovered that after the Supreme Court had heard arguments in the case but before it had issued a ruling, the President-elect James Buchanan wrote to his friend, U.S. Supreme Court Associate Justice John Catron, asking whether the case would be decided by the U.S. Supreme Court before his inauguration in March 1857. Buchanan hoped the decision would quell unrest in the country over the slavery issue by issuing a ruling that put the future of slavery beyond the realm of political debate. Buchanan later successfully pressured Associate Justice Robert Cooper Grier, a Northerner, to join the Southern majority in Dred Scott to prevent the appearance that the decision was made along sectional lines. By present-day standards, such correspondence would be considered improper ex parte contact with a court, even under the more lenient standards of that century. Buchanan's applying such political pressure to a member of a sitting court would have been seen as improper. Republicans fueled speculation as to Buchanan's influence by publicizing that Chief Justice Roger Taney had secretly informed Buchanan of the decision before Buchanan declared, in his inaugural address, that the slavery question would be speedily and finally settled by the Supreme Court.